Everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here with a little information on the Eastern District of New York case involving Robert Sylvester Kelly. And Judge Donnelly, I guess, finally got around to responding to some of these motions that were filed right before the trial began. She is finally doing a memorandum on her decisions. And so I'm going to jump right into this document and basically just read what she had to say. We already know that, there was a motion to dismiss that was filed, and she denied that motion. And so in this memorandum, she is basically explaining her reasoning behind denying, or her reason behind not dismissing the case as it was. And we all know that Mr. Kelly was ultimately found guilty on all counts in the indictment. The jury rendered their verdict on September 27th. So I'm just going to go ahead and read this for you all. It says, Ann M. Donnelly, United States District Judge. The defendant was charged with racketeering in violation of United States Code 18, sections 1962C and 1963. 3 counts of Mann Act transportation to engage in illegal sexual activity in violation of United States Code 18, section 2421A. 3 counts of Mann Act coercion and enticement to engage in illegal activity in violation of United States Code 18, Section 2422A, 1 count of Mann Act coercion of a minor to engage in illegal activity in violation of United States Code 18, Section 2422B, and 1 count of Mann Act transportation of a minor with intent to engage in illegal activity in violation of United States Code 18, Section 2423A, ECF number 43 on September 27, 2021. The jury convicted the defendant on all counts. In February and March 2020, the defendant moved to dismiss count 1 of the indictment and the accounts of the indictment incorporating New York Public Health Law Section 2307. I denied the motion. On the morning of jury selection, the defendant filed a second motion to dismiss the indictment, making some of the same arguments he made in the first motion. The government opposed. I denied the motion on August 18, 2021. This opinion sets forth the basis for that decision. So then she gives us the background, and it says, the third superseding indictment returned on March 12, 2020, charged the defendant with racketeering and violation of the Mann Act, specifically and as is relevant to the motion to dismiss. 2 of the racketeering acts 12 and 14, and 4 of the Mann Act counts 6 through 9, included allegations that the defendant had intercourse with Jane Doe number 6 in violation of section 120.20 of the New York Penal Law, reckless endangerment in the second degree, and section 2307 of the New York Public Health Law, PHL, which prohibits someone who knows that he has an infectious venereal disease from having intercourse with another person. The indictment alleged that the defendant engaged in unprotected sexual intercourse with Jane Doe number 6 without first informing her that he had contracted herpes and obtaining her consent to sexual intercourse in these circumstances. Racketeering Act 1 charged that the defendant, together with others, bribed a public employee on or about August 30th, 1994, in violation of Illinois Criminal Code sections 533(1)A and 55-1. Racketeering Act 3 charged that the defendant, together with others, confined Jane Doe number 3 against her will in or about and between 2003 and 2004, in violation of Illinois Criminal Code sections 510-1 and 55-1. Three of the racketeering acts charged, Racketeering Acts 2, 7, and 10, accused the defendant of inducing a minor to engage in explicit conduct for the purpose of producing one or more visual depictions of such conduct. Then she moves into her discussion. The defendant raised three challenges to the third superseding indictment. First, he argued that the PHL Section 2307 and CPL Section 120.20 charges should have been dismissed on the theory that the government could not prove the elements as a matter of law. The defendant contended that dismissing these charges would make venue inappropriate in the Eastern District of New York, and that the indictment should have been dismissed accordingly. Next, the defendant argued that Racketeering Acts 1 and 3 should have been dismissed because they were untimely under Illinois state statutes of limitations. Third, the defendant claimed the Racketeering Acts 2, 7, and 10, which charged the defendant with coercing a minor to create CP, would have been dismissed because there was no evidence that visual depictions existed. 1. Racketeering Acts 12 and 14 and counts 6 through 9. The defendant moved to dismiss Racketeering Acts 12 and 14 as well as counts 6 through 9. These counts charged that the defendant violated the Mann Act when he engaged in unprotected intercourse with Jane Doe number 6 without first informing her that he had contracted herpes and obtaining her consent to intercourse in those circumstances in violation of PHL Section 2307 and CPL Section 120.20. The defendant argued that pretrial dismissal was warranted because, as a matter of law, the government could not establish that the defendant violated either state statute. The argument is unavailing for the reasons explained below. Thus, the venue challenge also fails. A. PHL Section 2307. PHL Section 2307 prohibits someone who knows that he has an infectious venereal disease from having intercourse with another person. The indictment charged that the defendant had intercourse with Jane Doe number 6 without informing her that he had herpes or obtaining her consent to have intercourse in those circumstances. According to the defendant, herpes is not a venereal disease within the meaning of the statute. The argument is persuasive. The language of PHL 2307 is unambiguous and provides that any person who knowingly himself or herself to be infected with an infectious venereal disease has sexual intercourse with another shall be guilty of a misdemeanor. Herpes falls within statute's plain terms. See People, etc., Negron versus Superintendent Woodburn Correction Facility, and then it gives that case number, which was a case that was heard in 2006. And then it quotes, where the language of a statute is clear and unambiguous, courts must give effects to its plain meaning. courts construe words of ordinary import with their usual and commonly understood meaning, and dictionary definitions are useful guideposts in determining the meaning of a word or phrase. Walsh versus New York State Comptroller, which was a case from 2019, and then they go on to talk about the Merriam-Webster's Collegiate Dictionary and Black's Law Dictionary to interpret a state statute. Venereal disease is just an antiquated term for sexually transmitted disease. See Venereal disease, sexually transmitted disease, Black's Law Dictionary, 11th edition, which came out in 2019. The entry for venereal disease says, see sexually transmitted disease, which in turn is defined as a disease transmitted only or chiefly by engaging in sexual acts with an infected person, and also termed venereal disease. Emphasis is original. Merriam-Webster likewise defines venereal disease as a contagious disease such as gonorrhea or syphilis that is typically acquired in sexual intercourse. Venereal disease, merriam-webster.com, and then it gives the link. And then it goes on to say genital herpes is one such disease. The Centers for Disease Control defines genital herpes as a commonly sexually transmitted disease that any sexually active person can get. Genital herpes, CDC fact sheet, CDC, and then it gives a link that was last visited October 25th. And since this was dated October 26th, she was the person that had last visited that site. So moreover, New York courts have found that PHL section 2307 includes herpes. See Maharam versus Maharam, and that was a case from 1986, finding a duty to disclose genital herpes based on PHL section 2307. And then there was another case from 2015 using that same finding, which was Fan versus Sabin. To support a narrow reading of the statute, the defendant cited not case law, but a statement by the New York Department of Health's Public Health and Health Planning Council about a proposed, now adopted amendment to include HIV in the conditions that constitute the definition of sexually transmitted diseases for the purpose of certain sections of the public health law. Some commenters expressed concern that the proposed regulation could have the effect of making it a misdemeanor under PHL section 2307 for HIV positive individuals to have sexual intercourse in some circumstances. And then see New York Department of Health comments and responses on proposed amendment to Title 10 of the official compilation of codes, regulations, and regulations of the state of New York, sections 23.1 and 23.2 from May of 2016. And then she gives the link. Once again, she visited this on the 25th of October for the purpose of writing this document. So the agency responded that it interprets the law as only applying to individuals who knowingly expose another individual to acute bacterial venereal disease such as syphilis or gonorrhea. The agency's response says nothing about herpes. The agency was not asked to and did not express a view about herpes, nor does the statement overcome the plain meaning of venereal disease. The statutory language is unambiguous, and the court need not look beyond the plain meaning of the statute's terms. And so she is basically saying what I said when they filed that motion, that the documents they were using was referring to HIV, and if they wanted that charge dropped, then they needed to find some supporting documents that spoke specifically to herpes. But the argument they were trying to have was that even though they may have changed this definition of what a venereal disease is, that the actual penal code in the New York public health document or statutes has not been revisited or changed or updated to specifically state that herpes is included, and therefore the charge should have been dropped. So then she goes on to B, CPL sections 120.20. In addition to charging violations of PHL section 2307, Racketeering Acts 12 and 14 and 4 of the Mann Act counts charge that the defendant violated New York Penal Law section 120.20, which provides that a person is guilty of reckless endangerment in the second degree when he, recklessly engages in conduct, 2, which caters a substantial risk of serious physical injury to another person. Serious physical injury is physical injury which creates a substantial risk of death or which causes death or serious and protracted disfigurement, protracted impairment of health, or protracted loss or impairment of the function of any bodily organ. New York Penal Law, Section 10.0010. The defendant maintained that this charge is a factual impossibility because adult consensual intercourse usually does not lead to a serious physical injury, which would create a risk of death. In fact, there is a substantial risk that consensual sexual intercourse can lead to serious physical injury, protracted impairment of health, protracted disfigurement, or protracted loss or impairment of the function of any bodily organ. If, for example, one participant does not inform the other that he has a sexually transmitted disease, the defendant was charged with doing exactly that, having sexual intercourse with another person while he knew but did not disclose that he had a sexually transmitted disease. Moreover, serious physical injury under the statute need not create a risk of death. As the statute clearly says, serious physical injury also includes serious and protracted disfigurement, protracted impairment of health, or protracted loss of impairment of the function of any bodily organ. New York Penal Law 1010. New York courts applying the reckless endangerment statute have determined that infecting someone with a sexually transmitted disease without prior disclosure can lead to criminal liability under the statute. People versus Williams, which was a case from 2015. The defendant cited People versus Centola, a vehicular assault case, as support for this claim that the conduct alleged in the indictment was not reckless. Centola is entirely different. Centola was alleged to have driven his truck into a pedestrian so slowly that the collision merely pushed the victim and made him stumble. Centola, and then it gives where they're getting this information from. The court determined that Centola's conduct was ill-advised, unwise, and imprudent, but that there did not appear to be any reasonable evaluation of the facts which would lead to the conclusion that because of the actions of the defendant, the victim was in danger of a substantial risk of death, or that the defendant's actions could cause death or serious and protracted disfigurement, protracted impairment of health, or protracted loss of impairment of the function of any bodily organ. Those facts have nothing to do with this case. In short, a person who has sexual intercourse with another, knowing but neither disclosing that he has a sexually transmitted disease, nor obtaining his partner's consent, exposes that person to a protracted health impairment, which is the STD. The defendant also argued that the indictment did not allege the defendant caused serious physical injury. Racketeering Acts 12 and 14, as well as counts 6 through 9, were pled properly. An indictment need do little more than to track the language of the statute charged and state the time and place in approximate terms of the alleged crime. United States versus Yanati, quoting United States versus Alfonso, which was a case heard in the Second Circuit of Appeal in 1998. So U.S. Code 182421A makes it a crime to knowingly transport any individual in interstate commerce with intent that such individual engage in any activity for which any person can be charged with a criminal offense. Section 2422A makes it a crime to knowingly persuade, induce, entice, or coerce any individual to travel in interstate commerce to engage in sexual activity for which any person can be charged with a criminal offense. Counts 6 and 8 charge that the defendant did knowingly and intentionally transport an individual, to wit Jane Doe number 6, in interstate commerce with intent that such individual engage in sexual activity for which a person can be charged with a criminal offense, to wit violations of New York Penal Law Section 120.20, reckless endangerment, and New York Public Health Law Section 2307, knowingly exposure of infectious venereal disease. Counts 7 and 9 charge that the defendant did knowingly and intentionally persuade, induce, entice, and coerce an individual, Jane Doe number 6, to travel in interstate commerce to engage in sexual activity for which a person can be charged with a criminal offense. Violations of New York Penal Law Section 120.20, reckless endangerment, and New York Public Health Law Section 2307, knowingly exposure of infectious venereal disease. Racketeering Acts 12 and 14 charged the same conduct. Racketeering Acts 12 and 14, as well as counts 6 through 9, also included approximately when and where the conduct was alleged to have occurred, because the indictment recites each element of the federal offense charged and the approximate time and place each charge was alleged to have occurred. The charge was well pled. And this is so crazy because, you guys, if you go back to that Mann Act video that I did, that law needs to be overturned, because how do you have two consenting adults agreeing that one person is going to travel to see the other person, and then you turn around and charge that person with a crime when it was two consenting adults agreeing and making these plans together? It makes absolutely no sense. So then she goes on to Section 2, Racketeering Acts 1 and 3. The defendant also moved to dismiss Racketeering Acts 1 and 3 as untimely. Racketeering Act 1 charged that the defendant, together with others, bribed a public employee on or about August 30th, 1994, in violation of Illinois Criminal Code Sections 5/33-1A and 5/5-1. Racketeering Act 3 charged that the defendant, together with others, confined Jane Doe number 3 against her will in or about and between 2003 and 2004 in violation of Illinois Criminal Code Sections 510-1 and 5/5-1. The defendant argued that because the Illinois Criminal Code provides for a 3-year limitation period for these offenses, these predicate acts should have been dismissed. RICO charges are not governed by state statutes of limitations. Moreover, a racketeering act is not an independent count. Instead, it is part of the overarching overarching, I'm sorry, but we know it's overreaching, should be RICO offense. The relevant statute for evaluating the timeliness of a RICO action, U.S. Code 18, Section 3282, which prescribes a 5-year limitations period. See United States versus Hunter, which was a case heard in the Eastern District of New York in 2008, and United States versus Payne, which was an appeals case heard by the Second Circuit in 2010, and then something else came out in 2010. The Second Circuit has held in the statute of limitations context that jurisdiction over a single RICO predicate act confers jurisdiction over other predicate acts. United States versus Wong, which was heard by the Second Circuit in 1994, thus prosecution for allegedly violating Section 1962C, timely if the defendant committed at least one predicate act within the limitations period. Accordingly, and as the Second Circuit has recognized, a defendant may be liable under Section 1962C for predicate acts, the separate prosecution of which would be barred by the applicable statute of limitations, so long as that defendant committed one predicate act within the 5-year limitations period. The indictment charged the defendant with racketeering acts alleged to have taken place as recently as December 2018. Thus, the charges were timely. And so now you guys are seeing why it was so important for them to get Ariel to be a part of this case, because they needed something to have happened in the past 5 years in order for them to go back and then be able to charge him for things that happened in the 90s or allegedly happened in the 90s. And so this kind of stuff is like the government is going to figure out how to screw you in your behind one way or the other. And the fact that they can set up these type of rules to be able to go after people and prosecute people for stuff that happened 30 years ago. If people were paying attention, if average everyday American citizens were paying attention to these laws and how these laws are written, they would be in an uproar. But people don't care until it happens to them. And then when it happens to them, unfortunately, it is too late to do anything about it. So it goes on to say, Section 3, Racketeering Acts 2, 7, and 10. The defendant moved to dismiss Racketeering Acts 2, 7, and 10. Each charged the defendant with inducing a minor to engage in explicit conduct for the purpose of producing one or more visual depictions of such conduct in violation of U.S. Code 18-2251A. To prove this charge, the government was required to prove 3 elements beyond a reasonable doubt: that 1, the victim was less than 18 years old; 2, the defendant used, employed, persuaded, induced, enticed, or coerced the minor to take part in explicit conduct for the purpose of producing a visual depiction of the conduct; and 3, the visual depiction was produced using materials that had been transported in interstate or foreign commerce. And then they cite another Second Circuit case, United States versus Broxmire, which was from 2010. Racketeering Acts 10, 7, and 10 were pled properly. As explained in Section IB, an indictment need do little more than to track the language of the statute charged and state the time and place in approximate terms of the alleged crime. The indictment alleged the required elements. Each of Racketeering Acts 2, 7, and 10 stated that the defendant did knowingly and intentionally employ, use, persuade, induce, entice, and coerce a minor to engage in explicit conduct for the purpose of producing one or more visual depictions of such conduct, which visual depictions were produced using materials that had been mailed, shipped, and transported in interstate and foreign commerce. Each also stated the time and place these acts were alleged to have occurred. In asserting that, quote, there is no evidence that visual depictions exist, the defendant confused the standards of pleading with the standards of proof at trial. Unless the government has made what can fairly be described as a full proffer of the evidence it intends to present at trial, the sufficiency of the evidence is not appropriately addressed on a pretrial motion to dismiss an indictment. And then she cites the Second Circuit ruling, United States versus Alfonso from 1998. The government was entitled to present its evidence at trial, after which the defendant could challenge the sufficiency of the evidence pursuant to a Rule 29 motion. United States versus Rainier, and that was Eastern District of New York, 2019. And you guys know that's the Nexum case. Before the trial began, the government had not made a full proffer of its evidence in this case, nor was there a stipulated record. Thus, so long as the indictment was facially valid, which it was for the reasons described above, pretrial dismissal was not warranted. Conclusion: for these reasons, the motion to dismiss was denied. So basically what she was saying was that the government talked a good game, that they had all this evidence when in fact they really didn't have the evidence. So she couldn't dismiss the charge because the government had did the bare minimum in order to get, to say that they had this evidence and they would be able to prove their case. And so all of this is pertaining to the pretrial motions, but she's just now responding. And we can expect to see more of these coming out because there were multiple sealed motions that we still don't know what was in those motions that she has to respond to. And so hopefully she will respond to those eventually. But I am going to go back and read some of the notes that were in this document. And you guys remember the notes are at the bottom of some of the pages that further explains what she's talking about. And so let's see. So the first note, it says, in the second motion, the defendant sought dismissal of the entire indictment. I denied the motion on August 18, 2021. This opinion sets forth the basis for that decision. And then in note 2, it says, it is not clear that the second motion to dismiss was timely. The defendant filed it on August 9, 2021, after prospective jurors completed questionnaires, and on the morning that questioning of individual prospective jurors began. Federal Rule of Criminal Procedure 12b-3 requires certain motions to be raised pre-trial. Motions that fall under 12b-3 include claims of improper venue and defects in the indictment. Federal Rules of Criminal, I can't remember what the P stands for, Criminal Procedures. 12b-3, Rule 12c-3 provides that if a party does not meet the deadline for making a Rule 12b-3 motion, the motion is untimely. The defendant's attempt to evade this result by styling this motion as a 12b-2 motion not subject to 12c-3 is not persuasive. The arguments in this motion, which are dismissed in detail in the sections below, clearly fall within 12b-3, nor did the defendant establish good cause for the tardy filing. Indeed, the defendant moved to dismiss many of the same charges more than a year and a half before filing this motion. So basically, she was going to deny the motion anyway because they didn't file it in time. But she went ahead and explained what her answer was going to be had they filed it in time. And then, let's see, there were some more notes. Okay, then note 3. The defendant also asserted that permitting the reckless endangerment charge would amount to criminalizing adult consensual sexual intercourse, conduct which is unequivocally legal. This is similar to the challenge to the public health law charges that the defendant raised in his first motion to dismiss. The allegation in this cause is that the defendant had sexual intercourse knowing that he had a STD without disclosing this information or obtaining his partner's consent to have intercourse in those circumstances. As discussed above, this is cognizable theory of reckless endangerment under New York law. And then 4, going back to that, once again, why does he have the burden of proof to disclose the STD, but Faith didn't have the burden of proof to disclose the STD? And I'm wondering, like, when they file an appeal on this case, if they are going to, file a motion saying that they had evidence that she was also infected at the time, already infected at the time they met, and then maybe they can force her to turn over her medical records. I mean, it's just crazy. And then hopefully in the civil suit that's still pending, the lawyer that's handling that, hopefully he can force her to turn over her medical records and prove that she didn't have an STD or had not been diagnosed with an STD prior to her having sex with Mr. Kelly. So then we go on to number 4. This is in the note sections, guys. The defendant seems to have misstated the charges he moved to dismiss as untimely. In section 4 of his brief, the defendant argued that the allegations contained in count 1, racketeering act 1, racketeering act 3, racketeering act 5 should be dismissed, but the defendant did not discuss racketeering act 5 in section 4. In any event, racketeering act 5 was timely for the same reasons that racketeering acts 1 and 3 were. And then her note number 5, the jury found racketeering act 3 not proved beyond a reasonable doubt. And I believe that was the Jane Doe number 3. Okay, then number 6, the defendant did not address this well-established rule in his reply brief. Instead, he simply reiterated his claim that state law statutes of limitations govern federal RICO cases. I'm not sure what she's talking about there, or why she needed to put that note there. Then note 7, the defendant also argued that pretrial dismissal is warranted where the operative facts are disputed and the government fails to object to the district court's consideration of those undisputed facts in making the determination regarding a submissible case, citing United States versus Hall, but the operative facts were disputed. So she was saying that they weren't paying attention and that their motions were faulty. So what I am going to say is, I hope when they file this appeal that they find some appeal attorneys who can properly write these motions. I'm kind of surprised that Thomas Farinella fell short on these motions. Maybe he didn't have enough time to prepare. Maybe Canick came to him and told him to file these motions and he didn't have enough time to research. Because like I told you guys, I have seen him in court before on YouTube videos, and he does stumble a lot when he's talking, but some of the cases were overturned. So I don't know what his record is as far as appeals. But anyway, I hope they do find some strong appeals attorneys that are going to approach these charges and these guilty verdicts in the manner in which they need to be approached. And hopefully this man can, Mr. Kelly, can get these verdicts overturned, because I just, for the life of me, cannot understand how willing participants You know, just because you're disgruntled, things didn't go the way that you wanted them to, then you can just come in and make these allegations. And then with the whole Geronda Pace thing, he don't even know this crazy girl. Like, her mental health should have come up at some point, but of course Judge Donnelly didn't allow. She really had the defense's hands tied when it came to this case, because she would not let them bring in certain people. She ruled that certain topics couldn't be discussed. You know, she didn't want the parents coming in. She didn't want people's sex, not sex, didn't want their health records to come in, but then she wanted to drag his health records through the mud. And so it just seemed very, very unfair. And I just believe that, you know, without being a lawyer or, you know, knowing anything about the law, that they should have a strong appeal if they have the right attorneys in there. So guys, go ahead, let me know what you think about Judge Ann explaining why she denied all these motions. And let me know if future explanations come out, if you guys want me to cover that. I know it's a lot of technical jargon, but I did want to bring this to you where we already knew that she had denied certain motions, but here she's explaining why she denied them. So that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.